A very good evening, students. My name is Vishal. I'm a faculty of law at StudyIQ. Students, in today's class, we're going to discuss a very important legal point of view. We're going to discuss, can a woman be booked under the various provisions of POCSO Act? We're going to discuss, if a woman indulges in any sort of sexual activity with a child less than 18 years of age, can she also be booked and punished under the penal provisions of POCSO Act? Students, we all know that it is the responsibility of the society to ensure that the physical, mental and educational development of child takes place. And it can only be possible if the child is protected from sexual offences. Even in today's world, we come across news where we hear children getting sexually assaulted from sexual predators. You must have heard about a news in which a girl child was sexually assaulted by one of her neighbors. You must have heard about a news in which a child who has gone to school, he was sexually assaulted by a staff member of his school. Students, to protect the children from such sexual offences and to ensure that such sexual predators get adequate punishment, the government in 2012 enacted Prevention of Children from Sexual Offences Act. Students, recently Karnataka High Court has passed an order. Now, the question of law before the court was, can a woman who has indulged in a sexual activity with a male child whose age was 13 years be booked under the provisions of POCSO Act? So students, in today's video, we're going to discuss the important facts of this particular case. We're going to discuss the legislative policy underlying the POCSO Act. We're going to discuss the various penal provisions of POCSO Act. Apart from that, we're going to discuss what was the judgment or order given by the Karnataka High Court in this particular case. So the name of the case was Archana Patil versus State of Karnataka 2025. Now Supreme Court, the Karnataka High Court, has given a very stark observation. Karnataka High Court have said POCSO Act, being a progressive enactment, is intended to safeguard the sanctity of childhood and it is rooted in gender neutrality, with its beneficent objective being the protection of all children irrespective of sex. Students, in multiple cases, courts have come across a point of law. The point of law was whether the definition of child under POCSO Act includes only a girl child or whether the protection under the POCSO Act also extends to a male child. So Karnataka High Court has very categorically stated, as POCSO Act, it is a piece of legislation that ensures the protection of children. So that's why even a male child is entitled to the benefit of this particular legislation. Now students, I'm going to discuss in a very brief manner the facts of this case. The facts of this case were that there was a family living in a town in the state of Karnataka. So the family consisted of 4 people, parents and 2 children. And one of the children was a young guy of 13 years of age. Now in their locality, there was a woman who was a female artist. There was a woman who was an artist. So now as she was adept in multiple arts such as painting, drawing, so a lot of students from the locality used to visit the women for learning various art forms. So they used to go to the women and they used to learn painting, drawing, sketching, all of these. Now the parents in this particular case, they shifted to Dubai for a brief period of 4 years. In their stay in Dubai, they noticed that the boy who was just 13 years of age, his behavior underwent a sudden change. Now when the mother tried to inquire what happened to the child, after a lot of counseling, she got to know that the woman artist, she has sexually assaulted the boy. So when the children used to go to the house of the women used to take this boy in the bedroom and the women used to force this boy to have sexual intercourse with her. And this happened not one or two times, this happened repeatedly for a period of 4 to 5 months. After getting knowledge of the incident, the mother filed an FIR against the women. Now the woman was booked under the various provisions of POCSO Act, and now after getting booked under the various provisions of POCSO Act, she filed an application before the Karnataka High Court for quashing of the FIR. Students who are not from the law background, I must tell you, So there is a provision in CRPC and now BNSS in which a person can file an application before the respective High Court for quashing of an FIR. If the court feels that an FIR lodged against a particular person does not disclose the commission of any particular offence. So in that case, the court can quash the FIR, and when the FIR gets quashed, that means the legal proceedings against that particular person will be quashed. Now in this case, when an application was filed before the Karnataka High Court by the same women, now the court undertook a deep examination of the legal provisions of the POCSO Act. See, now in this class, we're going to discuss the legislative policy behind the POCSO Act. Students, POCSO Act was enacted in 2012 by the government. Students, one of the major reasons for enacting the POCSO Act was that India has ratified an international convention on the rights of child, 1989. Now, as per the provisions of the convention, it was a duty of every state who has ratified that particular convention to enact a domestic legislation to ensure that children get protected from sexual offences. Apart from that, it was duty of every state that has ratified the convention to ensure that the children do not get used in any sort of sexual exploitation. It was also the duty of the state to ensure that children are not used in generating any sort of pornographic material. In summary, it was the duty of every state to ensure that children are protected from sexual offences and they are given adequate chances, adequate opportunities to develop physically, mentally and educationally. See, POCSO Act was enacted in pursuance of the ratification by India of Convention on Rights of the Child 1989. The Act lays down that it is imperative that the law operates in a manner that the best interest and well-being of the child are regarded as being of paramount importance. Now, the Act itself says that the state shall take measures to prevent the inducement or coercion of a child to engage in any unlawful sexual activity. Now, it is a duty of the state to ensure that a child, a person below 18 years of age, he shall not be made subject to any sort of unlawful sexual activity. Now, students, most of you might have a question. If there is a child who is less than 18 years of age, suppose he is a teenager, he is of 15 or 16 or 17 years of age. Now, if any person who is a major, who is above 18 years of age, if he indulges in any sexual activity with a child, suppose the age of the child is 16 years, but child has given his consent or her consent. Now, in this case, can this person be booked under the provisions of POCSO Act? Because the child has given the consent. So, students, I must remind you that the law assumes that a child who is less than 18 years of age, he does not have the maturity of understanding to form an informed consent. A child does not understand the consequences of his act. That means the law presumes that a consent of a child less than 18 years of age is immaterial. It does not hold any significance under law. That means if a major, that means the person who is over 18 years of age, if he just try to convince a child to have a sexual relation with him, and the child out of the convincing agrees to have sexual relation, the law will still assume that the person has committed an offence under POCSO Act, because the law will deem that the child has not given his consent, or the consent of the child is not at all material. So, students, I'm again trying to repeat that the objective of POCSO Act is to ensure that a child is not exposed to any sort of sexual activity. A child is not exposed to any sort of sexual exploitation. Apart from that, a child is not used in generation of any sort of pornographic content. Now students, in this particular class, we're going to discuss certain important provisions of the POCSO Act. Students, I told you, under the POCSO Act, the definition of child has been made all-encompassing. The definition of child has been made inclusive. That means any person under 18 years of age, be it a male child or be it a female child. If any person above 18 years of age assaults a child, be it a male child or be it a female child, the person will be held guilty. Students, I will give you a stark fact. I'll give you a very stark fact and you will be surprised to hear it. In India, in case of sexual offenses, 46% of the victims are male child. Yes, it means that even male child are not, or in other words, male child are also equally vulnerable to sexual offenses. In all the sexual offenses, 46% of the victims are male children. Now see, so students, that's why the definition of child under POCSO Act has been made inclusive. It includes any child less than 18 years of age, irrespective of whether he is a male or a female. Secondly, Section 3 defines penetrative sexual assault. Now, Section 3 defines what is a penetrative sexual assault. So, any sort of penetrative sexual activity with the child will be considered to be an offense. Any sort of penetrative sexual activity with a child less than 18 years of age, it will be considered to be an offense. Now, a person who has committed any sort of penetrative sexual activity with a child, the person will be punished for a minimum punishment of 10 years. And the punishment can be extended to a maximum of life sentence. Now, students, this was the case about penetrative sexual assault. And one more thing, I would like to inform you that the word rape has not been used in POCSO. If you have read IPC or BNS, under section 375 of IPC, you would have heard the word rape. But under POCSO, the law does not use the word rape. It uses the word penetrative sexual assault. Now, under section 5, the law punishes aggravated form of penetrative sexual assault. So, under 3, we had sexual penetrative assault. Under 5, we have aggravated form of sexual penetrative assault. Now, what do we hereby understand by aggravated penetrative sexual assault? Students, if penetrative sexual assault, it is of such a nature which is dangerous to the health of the child. Because in multiple cases, it has been seen that during the course of penetrative sexual assault, a child gets severely injured. In multiple cases, we have seen even the child has died. In multiple cases, it has been seen that a child has reached into a permanent vegetative state. A permanent vegetative state means simply that a child is unconscious of its surrounding. He is so medically injured that he is not conscious of his surroundings. In certain circumstances, it had been seen that a female child has become pregnant after sexual assault. So, in all the circumstances in which a child suffers serious injury due to sexual assault, such sexual assault will be considered to be aggravated penetrative sexual assault. Apart from that, if a sexual assault is committed by a person who is holding any sort of authority, for example, a police officer, a member of armed forces, a person who is a school teacher or who is a part of any education institution, or a person who is a part of medical staff of a hospital, a person who is a member of any religious institution, a person who is a family member who is supposed to take care of the child. So now all of these people, if they abuse their position and they commit a penetrative sexual assault on the child, it would be considered to be aggravated penetrative sexual assault. Or if any person commits a child repeatedly, multiple times, or if any person commits a sexual penetrative assault on a child whose age is less than 12 years of age, it will be considered to be aggravated form of penetrative sexual assault. So now, students, I like to tell you a principle of criminal liability. The more is the gravity of the offense, the more is the punishment. The lesser is the gravity of the offense, the lesser is the punishment. So students, if any person commits a grave offense, a higher category of offense, obviously the punishment will be more stringent. So students, a person who has committed aggravated penetrative sexual assault, his minimum punishment is 20 years. Secondly, it can also extend up to life sentence. That means a person will not be given the benefit of commutation. That means once a person has been convicted, for rest of his natural life, he will stay in prison. He will stay in prison. He will not get the benefit of commutation. That means his sentence cannot be reduced. In normal conditions, if the behavior of a person who is given life sentence, if the behavior is good, if the authorities feel that the person can be reintegrated into society, his punishment is commuted. So such person, life sentence of such person is commuted to, for example, any term more than 14 years, 15 years, 20 years, 25 years. But in this case, a person will not be given benefit of commutation. And thirdly, death penalty can also be awarded. So this is one of an offence. Aggravated penetrative sexual assault is one of an offence under Indian law in which death penalty is provided. So it is important to make people aware that under the Indian law, in case of aggravated penetrative sexual assault, even death penalty can be given. Now, after reading different provisions, major penal provisions of POCSO Act, now we'll try to understand what is the definition of child under the Act. Because I've told you, court have come across multiple cases in which the court was in conundrum whether the child includes a female child or it also includes a male child. So see, the court, Karnataka High Court in this case has categorically stated that children would include boys and girls who are minors below 18 years of age. The Act does not mandate protection only for girls. The children who are boys and boys who are below 18 years do have the same protection. So the court has once again categorically stated that even male children, even boys who are less than 18 years of age, they are also entitled to protection under the POCSO Act. If any sexual activity is committed on such male child, the person who has committed such activity, he will be punished under law. Secondly, the court has categorically stated, now the question, the court has categorically stated and the court has categorically answered the question, can a woman be an offender under POCSO Act? Because the case, the major question of law in this case was, can a woman be also convicted under the provisions of POCSO Act? The court has said yes. The court has said yes. The court said the underlying policy behind POCSO Act or the legislative intent behind enacting POCSO Act was to ensure that children are protected from sexual act. Children are protected from sexual offences. So that means it is a duty of the state to ensure that children do not encounter any form of unlawful sexual activity. So that means they are protected from any person who tried to commit sexual activity with them. So that person can either be a male or that person can be a female. So that means POCSO Act is a gender neutral law. How? One, a child victim can be a female child. It can also be a male child. Because I have given you the data that out of sexual offences in India, 46% are committed against male child. Secondly, POCSO is a gender neutral act because in this case, anybody who assaults a child, anybody who sexually assaults a child, whether it be a male or a female, the person will be considered to be a perpetrator. The person will be punished according to the penal provisions of POCSO Act. So students, I would like to read the observation of the court, respectable High Court. The court explained that the statute is comprehensive, designed to encompass acts committed by any person, male or female, and the gender of the perpetrator is immaterial. What matters is the act and the involvement of the child. So the court has categorically stated, we are not concerned about whether the perpetrator was female or a male. If a sexual act has been committed against a child, and if sexual act has been committed plus the victim is a child, so the person will be held under the provisions of POCSO Act. So in this case, the court has once again categorically stated that women can also be booked under the penal provisions of POCSO Act. So students, in today's video, we have learned what was the legislative policy behind enacting POCSO Act. We have also learned what are the major penal provisions under POCSO Act. What are the punishment that can be awarded to a person who commits any of sexual act under the POCSO Act. Apart from that, we have also learned that POCSO is a gender neutral law. That means a victim can either be a male or female child. It also means that a perpetrator, an offender, can also be a male or female who commit a sexual activity with a child. Apart from that, we have also learned that the consent of a child below 18 years of age is not material at all. The law will not give a defense to the perpetrator of sexual conduct who takes a defense or who states that the child has given its consent. No, the law will not at all give you such defense. So students, in today's video, we have learnt about the judgment given by Karnataka High Court. So I would like to wind up the video here only. So for next video, please stay connected with StudyIQ. Till then, please take care of your health. Ensure that you make sincere efforts towards accomplishment of your goal. Until then, Jai Hind.